All right, good morning. My name is Sarah Gertis, and I'm the editor-in-chief of the Pepperdine Law Review. On behalf of the Pepperdine Law Review, welcome to this year's symposium on international arbitration and the courts. Thank you to everyone in attendance here in Malibu and those in DC and elsewhere live streaming in. Over the past several decades, international arbitration has become a preeminent means of resolving complex transnational commercial disputes. With the rapid expansion of the field, many issues have arisen, specifically issues arising from the dynamic relationship between international arbitration and the courts. The Law Review is fortunate to have such a sterling lineup of experts here from around the globe for this symposium to engage in thought-provoking discussions regarding those complex issues stemming from the interplay between arbitral tribunals and the courts. The speakers today are the best of the best in international arbitration and are all actors in the rapid change that is occurring in the field. The Law Review would like to extend a big thank you to all of our esteemed symposium participants and moderators that we will be hearing from today. The Law Review would also like to thank our co-sponsors, Professor Jack Coe and Professor Trey Childress, for all their work. Without them, this would not have been possible. Thank you to Catherine Eschbach, our symposium editor, for all of her efforts in putting together the symposium. And thank you to the Law Review's faculty advisors, Professor Edward Larson and Professor Robert Pshaw, for their guidance. Thank you to all of the faculty and staff at Pepperdine for their support of the Law Review and this event today. A big thank you to our Dean, Dinel Taha. Before coming to Pepperdine, Dean Taha served as a judge for the United States Court of Appeals for the 10th Circuit from 1986 to 2011, serving as the Chief Judge of the 10th Circuit from 2001 through 2007. Unfortunately, she is unable to be here today, but she wanted to pass on this message to you. Greetings and my congratulations on this important symposium. I welcome this distinguished group of scholars to the Pepperdine University School of Law. We are so proud to host this Law Review Symposium on international commercial arbitration. The topics discussed here and your work in this field are critically important to the future of international dispute resolution and the world's ability to address contentious and challenging issues that confront the global economy. The work that you are doing and our goal here is to help make progress and orderly economic growth a reality through effective and informed arbitration techniques and to strengthen the law of arbitration that governs these processes. I regret that I am unable to be with you, but I assure you that I will follow your work closely and read the papers that are presented here. I thank the Pepperdine Law Review and Professors Jack Coe and Trey Childress for their leadership and inspiration in convening the symposium. My best wishes for an interesting and productive time at Pepperdine. Thank you, Dean Taha, for your message. The Law Review would also like to thank Professor Thomas Stepanowicz. We are lucky to have him on the faculty here at Pepperdine, and we are thankful for his support and contributions to this symposium. Professor Stepanowicz holds the William H. Webster Chair in Dispute Resolution and is academic director of the Straus Institute. He's a longtime arbitration scholar and co-author of Federal Arbitration Law, a 5-volume treatise on the Federal Arbitration Act cited by many courts, including the United States Supreme Court. For 5 years, he served as the president and CEO of the Manhattan-based International Institute for Conflict Prevention and Resolution, a thought leader in commercial dispute resolution. He is an active arbitrator and dispute resolution professional with international and domestic practice. Professor Stepanowicz heads the Straus Institute's empirical research program, currently engaged in groundbreaking research on practices and perspectives of corporate counsel, experienced arbitrators, and mediators. Among other honors, he has also received the ABA Dispute Resolution Section's D'Alembert-Raven Award, its highest honor for contributions to the field of dispute resolution. It is my honor to introduce to you Professor Thomas Stepanowicz.
Thank you very much. It's a delight to be here today. I'm so pleased to see such a diverse crowd. I think you're really going to be in for a treat during today's presentations. On behalf of my colleagues at the Straus Institute and the School of Law, it's truly a pleasure to welcome this outstanding group of luminaries, as Sarah said, from the field of international arbitration to Pepperdine University. You know, this confluence is no coincidence. It began, as Sarah said, with the efforts of my friends and colleagues Jack Coe and Trey Childress, and the truly outstanding spade work done by Sarah Gerdes, Catherine Eschbach, and others. But you know, it's no coincidence in a larger sense. I want you to think of today's program as, in fact, a station, a stopover, on what has become a perpetual, movable feast of international arbitration. It reflects the unprecedented focus on international arbitration by an expanding global array of practitioners, scholars, and students, all of whom seek to come to the table. It's reflected in a continuous polyphonic conversation. It's comprised of conferences and symposia like the one you're attending today, and in fact, a number of these people were together last week for a conference, and a number of us will see each other in London in 2 days. There are academic programs at the undergraduate and graduate levels, a proliferation that includes our own specialty LLM in international commercial arbitration. There are an unending parade of professional organizations and other institutions, all of whom are seeking to establish themselves and establish a platform for their products, for their ideas, and for their space at the table. There are empirical investigations. In your packet, you will see a couple of articles that just came out, or just being published in George Berman's American Review of International Commercial Arbitration that focus on practices and perspectives among American arbitrators, many of whom also do international work. Thanks to listservs such as OGMID, I guess that's the way we pronounce it, this perpetual conversation confronts us on a daily or nightly basis, even hourly, even by minute. I can tell you that sitting in my office at 7 o'clock this morning, I already had about 20 messages relating to international arbitration. It's international arbitration's equivalent of cable news, 24/7. But if there's a symbol for our movable feast, it is the VIS, the Willem Vis Moot Court Competition, which now draws thousands of participants from hundreds of law schools to Vienna or Hong Kong, including our own Sarah Gerdes and a number of other students, including some of our international LLM students. Now, in what I like to refer to as and forgive me, the kabuki theater of international arbitration, VIS participants are called upon to accept total immersion. That is, to pore obsessively over a factually complex, procedurally convoluted fact pattern and gird their loins to contest every potential foot of ground, to parry blows from the most unlikely quarters, all in what is for most a forlorn hope of running a gauntlet of diverse tribunals and attaining eventual victory. Now, in today's movable feast of international arbitration, we're invited and challenged to repeatedly sink our teeth into a range of subjects that somehow present themselves week by week in never-ending variety. We munch on lex arbitri with aperitifs. We share a gateway issue or two for a first course, then tuck into joinder and consolidation, and then follow up with varied examples of immunity from execution. But not satisfied with that, we go out in the kitchen to rustle up some third-party funding, or Aaron would have us look at extraterritoriality and discovery. Then we wind up foraging out in the garden for various conjured forms of international dispute settlement. And when all is said and done, we know that our mastication, or if you will pardon the expression, our vis-oration of arbitration, we know that it will commence again tomorrow or next week with a new menu, or more likely, new and more sophisticated variants on this week's menu. So welcome all you who seek a place at the table to today's setting in the feast of international arbitration. We have for you a particularly delectable menu concocted by arbitration's iron chefs. We invite you to tuck in. And without further ado, I will turn the feast over to our own master chef, Jack Coe. Thank you.
Well, I would like to add my welcome very briefly. It's hard to follow an act like that. Feeling a little indigestion at the moment. But I loved it. You can see why it's such an honor and pleasure and just good fun to teach here, because not only do we have a good sense of humor, but there's so many arbitration wonks. You can throw a biscuit in any direction and hit one of us, and we've perfected the art of clearing a room by talking about gateway issues and other kinds of things. My first duty this morning is to introduce and attempt to moderate what I know will be a very skillful presentation by my friend Jan Schaefer. Jan is a partner at the Frankfurt office of King and Spalding. More importantly, he's a friend of mine, and I consider myself lucky to be able to say that we worked together on a couple of matters, and it's no exaggeration to say that in these matters he was, in a room full of lawyers, perhaps the most important one, because one of the issues we were dealing with depended very much on how a German lawyer might look at it. And yes, he was the only German lawyer, and certainly also perhaps the smartest guy in the room. Now, part of the reason I invited him is he's overcome some serious hardships in his life. For example, he has an LLM, but it's not from Pepperdine. Notwithstanding that, he's managed somehow, with the sheer force of his will, to publish early and often, to sit as arbitrator, to work for one of the elite firms in the arbitration community, and to maintain a sense of humor the whole time, which I think is admirable. I would like to just now turn it over to him. He gave me permission not to go through his entire CV, which the short version is 20 pages. I commend it to you, though, because he's written a lot of penetrating things, and by all means, do have a look at it. But we start this morning with a mini topic about court assistance to arbitration, and my job as sort of moderator is to more or less resist the temptation to interrupt him too much, but keep that prerogative if I just can't help myself. And then to make sure that we have some time at the end for the questions, which you are encouraged to write down on the cards that have been made available to you. And so, with no further ado, except perhaps to ask my law review colleagues to bring us a couple bottles of water, that be possible? May I turn the mic over to my friend Jan Schaefer?
Well, thank you very much, Jack, for your kind words. I have to disclose I'm not an early bird, but since we have some time difference, you're lucky. I'm awoke. Arbitration and the courts, that's a topic with many facets. And, if all things work out well between the parties and the arbitrators, there's often in practice no need at all to get the courts involved. So we could have the feast or the party all to ourselves. But if something goes wrong, then it's necessary for the courts to step in. This morning I would like to address 3 questions with you. The first one is, why is court assistance needed at all in arbitration? And I think I'll approach that by comparing judges and arbitrators and see what are the differences and what these differences tell us about the need of court intervention. Secondly, I will ask the question, who's actually supported by the courts? Is it the parties, the arbitrators, or is it the institution of arbitration itself, or maybe all 3 of them? And if so, what consequences flow from that? And last but not least, the third question I would like to touch upon is the question of how do the courts grant the assistance? So then looking at some practical examples, and also raising the question, what role does the arbitration law play? and what role does the goodwill of the judges play when they apply the arbitration law? And I would like to end with a note on saying, well, we all need the courts. Even so, in many cases, they don't play any role at all. But we need the lawmakers to set the framework, and we need the judges to apply the framework. And currently, there's quite a bit of a backslash on investment arbitration in particular, but that also flows over to commercial arbitration in Europe. If we think about the negotiations of the transatlantic trade and investment partnership, that's a big debate in Europe right now, the values of arbitration. And then also there are judges who now question arbitration, say, well, a lot of cases just go to arbitration. They no longer end up on their dockets. And they say, we're lacking certain areas, case law. And they say, how do we fix about that? So there are quite a bit of issues now here where the lawmakers and possibly the judges are no longer that favorable to arbitration. And that's something that I think we need to very carefully watch as an arbitration community. Well, then let me turn first to the question, why is court assistance needed? I submit a good answer to that question is by comparing judges and arbitrators. Well, both groups are called in to deliver justice. They are fulfilling a judicial function, and you could even say that the arbitrators, they are vested with even stronger powers than the normal first instance court judge, because arbitration awards are final. There's no appeal. Whereas if you are a judge in first instance, you always have the appeal judges above you. They're going to check you, they're going to control you. So what the arbitrators have is quite a powerful mission. But there are limits to their powers. And I think these limits, and I think there are 3 of them, they are going to inform why we need court intervention in arbitration. The first limitation is arbitrators are constituted, or arbitral tribunal are constituted for a specific case. They have no permanency. If you look at judges, there's a judge on duty, but there's no arbitrator on duty. If you want to get an arbitral tribunal to look at your case and to make a decision, you first of all need to constitute that arbitral tribunal, and it does take some time to do so. Even if you're very quick, and normally you nominate your arbitrator, then the other side has 30 days to nominate its arbitrator, and then you have another 30 days to get the third arbitrator who's going to chair the tribunal to be appointed. So in an ideal world, you could get it all done in 2 months. But in reality, there are a lot of opportunities to frustrate that process. So the respondent is not cooperating, then he's not nominating the arbitrator, then there might be issues of conflict of interest with arbitrators, so they are challenged already before they've been properly appointed. And then maybe it's difficult to find the third arbitrator and to agree on that. So it can take quite a substantial time to get the arbitral tribunal in place. And then you have a situation that there's a time gap between the dispute arising and the arbitrators, the decision makers, being in place. And as you can imagine, there are a lot of situations where a party would need to get some protection in that time span. If you just think about, as an example, interim measures. So the other party is trying to dissipate the assets, or you have critical evidence that might get lost because a party is not cooperating, or you have a third party who has evidence and you just need to get hold of that. These are situations where you definitely need somebody to step in, and that's the courts. And since there's this necessity to have court involvement, the arbitration laws typically state that having an arbitration agreement doesn't prevent a party to apply to the courts, the competent courts, for interim measures. So that's a kind of a safeguard so that people have the opportunity to get interim measures. Sometimes the question arises in practice, well, can't we just get rid of that? Because we don't want to get court involvement at all in that stage. Can the parties waive the right to go to the courts for interim measures? If you look at the German jurisprudence, the courts say, well, you can waive access to court interim measures, but you can't do that until the arbitral tribunal is in place, because there is this gap, and this is quite a risky gap, because it can be a point in time, quite a long point in time, where you cannot get any access to justice if you waive it. So this is not validly done in Germany. So you always have the opportunity, if you have a German arbitration seat, or even if you have a German party involved and you need interim measures, you can always go to the courts. But of course, arbitral institutions and the arbitration community, they have been aware of that time gap and said, well, we need to fix it somehow, and can we do it on a contractual basis? And everyone who has been involved in the Wies arbitration mood this year, they know it's the emergency arbitrator. That's something that can fill the structural gap before the arbitral tribunal is appointed. And what you can see is it's an effort by the arbitration community to make sure that something is available. So many arbitration institutions now have these emergency arbitrators. I think it will be very interesting to see in practice whether there will be more demand for emergency arbitrator relief than there was a demand for courts to grant interim measure before the arbitral tribunal has been constituted, or to preserve evidence. So the question is, does the new offer of arbitral institutions, of emergency arbitrators, create a demand that hadn't been there in practice before? But of course, even if you have an emergency arbitrator, there's a second limitation. That's the next point I would like to talk to, and that's arbitrators have no imperium. Arbitrators have no coercive powers. And that's a limitation because arbitrators, they can render decisions, but these decisions need to be enforced if somebody doesn't comply with them. They are not self-enforcing. And if you look at it, I haven't seen any law, and maybe you can help me if I overlooked something, that empowers an arbitrator to issue coercive measures. That's something which is totally the monopoly of the state. And similarly, because normally you say in arbitration there's party autonomy, so parties can agree. But since the state has the monopoly for coercive power, the parties cannot confer that by agreement to the parties.
Can I just ask, we often talk about these sort of softer forms of coerciveness or sanction by the tribunal, for example, negative inferences, allocation of costs. Do you think that is ineffective in comparison to the what we would call the contempt power that courts have? And does it matter whether we're talking about something involving one of the parties or a third party?
Right. I think these tools are quite powerful because you have one shot in arbitration and you have one arbitral tribunal. So you want to make sure that you don't lose the favor judicem, as we say. So the favor of the judge who's going to decide your matter. So normally parties are very careful that they don't mess it up with the arbitrators, because the arbitrators have some informal power and some tools. But if these tools do not play out well, because one party really tries to frustrate it, I think then you really have to fall back again on the courts. And I think that's the limitation, and you cannot overcome it. You can draw negative inferences, but then the question later arises, maybe at the enforcement stage, was that validly done? On what basis have you done? So you might run into the next series of issues when an arbitrator takes that road. Well, if you have this self-executing, if you don't have the self-executing, so you need the state to step in. So the courts are also the kind of gatekeepers for an arbitration award to become an enforceable title. And again, it's the law that stipulates what test is to be applied, what the courts have to review before they can grant the enforcement of an arbitration award. Today, I think there's a kind of a very broad consensus that the courts are not entitled to review the substance of the dispute when an arbitration award comes before them. So they're not a kind of appeals facilities, but they just look at very procedural issues like have there been the right to be heard, Has there been equal treatment? Has the arbitral tribunal complied with the arbitral procedure that the parties agreed upon? Was there an arbitration agreement? All these very basic issues, but they don't look into the merits. The French say there's no révision au fond, so you can't look into the law. If the arbitrators got it wrong, they got it wrong, and you can't really help it. I think if you look at it from a European perspective in the United States, I think we always feel the Americans try to sneak out of it with their manifest disregard of the law exception. But I think you're something maybe I can learn here. But you know, this is like the broad consensus. You can't really try to open the case if you go to a judge. But even if you look at what the courts do when an arbitration award comes before them, it's normally phrased, it's court control. But if you take a broader perspective, I think even court control you can regard as a way of court assistance to arbitration, because without the threats of enforcement, I think arbitration wouldn't be as effective as it is today. Because you don't need to go to the courts, because they are always lurking in the background. So if somebody doesn't comply, the other party can go to the courts. And that threat itself makes arbitration very effective, because parties voluntarily comply with it. But I think you just mentioned that. What happened with third parties? I think that's the third limitation that arbitrators face. So the arbitral competence and jurisdiction is based on the arbitration agreement. And the arbitration agreement is a contract between the parties to it. And that contractual limitation also translates into a limitation of jurisdiction. So arbitrators cannot reach out to third parties unless they have submitted to the arbitral tribunal's jurisdiction. As you can imagine, there are a lot of situations where in court litigation it's very convenient and very important for parties to have the possibility to get third parties involved. Think about joining third parties. If you have relationships between an owner, a contractor, and a subcontractor, it can be very critical to make sure that there's justice for the sandwiched contractor, to make sure that everybody can be joined in the same proceeding. You have a uniform decision taken, and the contractor is not ending up losing the case against the owner and at the same time losing the case against the subcontractor, because different people take different decisions. But also if you look at evidence, a lot of evidence is with third parties, be it witnesses, be it documents, and that's a situation where the arbitrator comes to a limit. And traditionally, when we speak about court assistance to arbitration, we think about that area, the area of getting access to evidence which is not with the parties, not in the control of the parties. And then the big question arises, how do you do with that? What kind of support do arbitrators get? And I think the support that arbitrators get, that's spelled out in the law and then applied by the courts. So that's the aspect I would like to look at next. Who's actually supported? Is it the parties, the courts, the parties, the arbitrators, or the arbitration itself, the institution of arbitration, the method? If I speak about parties, that's probably not quite right, because it's always singular, it's a party. So there's no need that both parties get together to go to the court, but equally the court cannot make decisions sua sponte. So they cannot say without an application, I just want to walk into this arbitration, I don't like what I hear about it, I need to intervene. The court always must be seized. It must be seized by a party or by the arbitral tribunal. And if we look at a provision, how has a legislator got its head around this? If you look at the German arbitration law, there's a provision in 1015 which provides for court assistance in the taking of evidence and also with respect to other judicial acts. And this other judicial acts, that's an amendment, a German amendment to the provision of the model law. So when Germany adopted the model law, also the provision on court assistance in the taking of evidence was adopted, but that one was a little bit extended. And interestingly enough, in Germany, it's not the parties who can apply for it without the leave of the tribunal. It's either the arbitral tribunal or the parties or one party with the leave of the tribunal. And one might question this from a policy perspective and say, well, isn't it the party who knows best how to present its case? Why is there a kind of gatekeeping function of the arbitrator involved in that process? And while it's probably true that a party knows best how to present its case, there are a number of parties who are not really cooperative in an arbitration. They're trying to frustrate the proceedings, and every court involvement is also the risk of a derailing of the arbitration to make it more complicated, just to frustrate the proceedings. So the arbitrators assume the role of a gatekeeper to make sure that they decide what's helpful to the arbitration. And that's also the stance that the German legislature took when they said it's only the arbitral tribunal or the parties with leave of the arbitrators who can make an application.
Is there much precedent for the tribunal asking for help in Germany, for example?
Well, normally I think if you look at the practice on that provision, it's normally triggered or suggested by a party, because that's the normal. The arbitrators, I will come to that a little bit later. There's one situation, it's the taking of the oath for witness examination, and that's basically triggered by the arbitrator's initiative. So they say, well, that's a good idea to take, so we want a party to be examined by the court, by the judge who can take an oath. So there will be criminal sanctions if that witness lies. But normally when it comes to support of the courts to hearing witnesses or trying to get hold of evidence, it's normally the party that approaches the arbitral tribunal and say, well, we need that for the following reasons. Can you grant us leave so we can make the application to the court? But what happens if an arbitral tribunal disagrees with the party who wants to involve the courts? The arbitrators can say no. And if they are bold enough, they will say no if this is regarded to be just a means of complicating things, frustrating the arbitration proceedings. But of course, again, there's some policing power by the courts. They can check later on if this kind of denial of the application amounted to a violation of the duty to give the parties an opportunity to present its case. So there's always a kind of round back. You can circle back and get the courts involved, but the arbitrators, they're the gatekeepers of that process. So basically, this provision is not necessarily in aid of the parties, but merely indirectly, but it's a provision in aid of the arbitrators, because the arbitrators can apply. Whereas if you look at interim measures or if you look at enforcement, it's a measure which is applied by the party. So I think it's fair to say this is a kind of court assistance in the support of a party. But last but not least, I think the entire mechanism of involving courts, what the legislators have designed, what opportunities exist to get the courts involved, what tests are imposed on the courts when they exercise their support, that's also all done in support of arbitration itself. While we can all say arbitration is a creature of party autonomy, it's all right. It's the basis for arbitration, and many arbitration proceedings can be done without any court involvement. But arbitration only becomes effective and a real alternative to court adjudication once you have this kind of possibilities lurking in the back that a party can apply to the courts to get things enforced, that you can enlist the support of the courts if you have one of the lacunae. And that is the situation that you have the time gap issue, that you have the coercive power gap issue, or you have the gap of reaching third parties, and if that's necessary, you need to have the courts involved. So, but why do the courts grant support to arbitration? Is it because they love arbitration? I doubt. They do it because the lawmakers say so. They say, well, there's an opportunity, there's a power, there's a competence spelled out in the arbitration law that a party can rely upon. They can make an application, and the courts have to entertain it. And of course, the question is, what kind of applications can you make? And if you look at the model law, there's quite a critical provision, that's Article 5. And it says that no court can intervene unless the law, the model law, provides for such an intervention possibility. This has been hailed by many as this is a landmark decision. This has been quite a very successful lobbying effort for arbitration, because there is no inherent powers of the courts to intervene. There can't be surprises. If you know the law, if you know what's spelled out, you know what the courts can do in terms of court control and what the courts can do in terms of court support. But of course, if you look at it, I think when we speak about court control, everybody is very keen to limit it. They say, well, the judges should apply their powers restrictively. When it comes to vacating arbitration decisions, the grounds should be construed narrowly. They shouldn't go overboard with these things. But some people and commentators say, well, if we speak about court support, that's something positive, so we should not be limiting judges too much. But if you look at the spirit of Article 5 of the model law, which has been incorporated in many countries, I think that would be an approach which is contrary to that spirit. So you should not assume inherent court powers. But of course, what is very much in compliance with Article 5, if courts apply the powers that they expressly been granted by the lawmakers, that they apply them flexibly and in a very liberal fashion, just to make sure that the purpose of court assistance is achieved.
Can I ask about the party autonomy in this connection? To what extent, under the German regime, could parties enhance the powers of courts? In other words, sort of add to Article 5.
Right. Well, that's an interesting debate. I know that it has a US background as well. In Germany, this would not be possible. So the parties, they are not the masters of the court. They are the masters of their own fate, so they can agree whatever they like. But, you know, the courts are a public resource, and they cost money. And the parties just can't say, well, we want the courts to do something more than the law spells out. This also applies if you can have a second appeal level. Say, well, it would be nice to have the courts review the arbitration award, because we don't want arbitrators to make mistakes in the law. We want them to get things right. But German courts would not accept that.
So they can't expand Article 34.
No. What they can agree is they can agree on a second arbitral tribunal to review things. That's possible. But again, it would be the money from their own pockets they need to spend on the arbitrators. It's not, they cannot use the public resource of the courts. But let's take a quick look before I conclude on practical examples. We had this Article 1050, so the courts can support arbitration in the taking of evidence or with respect to judicial acts on application of a party, or the tribunal itself find it useful to enlist the help of the courts. What are the cases that you see in practice? Well, first of all, you don't see many. I've picked out two cases. One of the cases is about getting a witness examined. There was an arbitration in Denmark, and the witness was based in Germany. And the party tried to get the witness to the arbitration. Even the arbitrators invited the witness to come to Copenhagen for a hearing. The witness refused. So one party said, well, this is a critical witness for my case. I want that witness to be examined. And they pulled out the German law and said, well, this witness is based in Germany, and there's a provision. The courts can help. And the courts even can help if the arbitration takes place abroad. That's also spelled out in the law. It's not limited to Germany-seated arbitration proceedings. And here, the party applied to the arbitrators and said, I need that witness. And the arbitrator said, we grant you leave. You go to the court, you make your application, and then we'll see what the judge says. So they made the application to the local court where the witness was based. The judge was responsive and said, yes, you showed me that there was leave of the arbitral tribunal. We can have that application run. And then the big question arises, well, how does the whole thing proceed in practice? Because it's just, well, you can go to the courts, but what's happening? Everybody who has ever done a kind of Hague Convention application for, let's say, deposition of a US witness in Germany, knows that it's probably not a good idea to go to the German courts to obtain that evidence, because the German courts apply German civil procedure. And there's no cross-examination, there is no close questioning of close questions, there's no verbatim transcript, and the judge, they don't really take an interest in the whole thing because it's not their matter, it's just a waste of their time in their perspective. So the same might happen if you go to the local court with your witness for the arbitration. But then, interestingly enough, the law also states again, everything will be done according to German civil procedure. So the witness can rely on all the rights to refuse testimony that it also would have had if it was a German court proceeding. There won't be any cross-examination. It will be basically the judge asking questions, but the judge doesn't know anything about the case. So, and that's what the lawmakers identified, so they said the arbitrator can ask questions. So basically what's normally done, the judge is sitting there and he's just delegating the question power to the arbitrator. So the arbitrator can ask the questions, but the whole thing gets very delicate once a party tries to ask some critical questions on the witness. In German litigation, every party can always ask questions, but these questions are normally asked after the judge has asked the questions. And if somebody is trying to ask close questions and leading a witness up the garden path, this is quickly stopped and considered inappropriate by the judge. So it's a very, very fine line. You say, well, I really have a critical point and I want to get it across that the witness may be lying and not really being in compliance what really the fact said in the past. Then it's a very, very delicate thing to do. The same as if you want to get a transcript. Many judges say, well, we don't have transcripts in civil litigation. And then it's a matter of negotiating with the judges so that you put your court reporter in there. But some judges say, well, the witness needs to agree. Because after all, you go to the court, and after the witness has done the witness examination, there can be an oath to affirm that everything which has been said was right. So this is done differently. It's not like in the beginning you tell, well, you know, you tell the truth, but if they've given the evidence and somebody feels, well, I have some doubts what has been said, then you can apply to the judge to put a witness under oath. But that's an exception again. So it's quite different from the way it works in arbitration. So if an arbitrator is concerned about having a level playing field, so everybody should have the same opportunities to question all witnesses, you need to be very careful how you play with this opportunity. And the second example I would like to give is the oath. Sometimes you see witness statements as an arbitrator and say, well, it's the same point, but they are totally different situations, and both witnesses put them in writing. So it's not just the lawyers telling, well, we have this narrative and we have the counter-narrative, but witnesses really saying, I'm standing behind this storyline. And if you feel as an arbitrator, well, there must be something wrong, somebody must be lying, it's quite an efficient means to tell the parties, actually, we've seen the witness statements, we have issues here, but we are going to examine the witness before the German court, and the court is going to take an oath afterwards. And guess what? In many cases, suddenly a witness is withdrawn. And that's the witness who got cold feet, because they say, well, there are serious criminal sanctions if you lie in court and you are under oath. So this is quite a nice mechanism just to make sure that everything plays out ethically right. Okay.
Can I just ask, and my question I think probably is answered by the architecture of the model law, but we talked about concurrency with the tribunal and the courts, and the model law as implemented in Germany says they're the gatekeeper. They have to give leave or themselves make the request. What about courts of the seat and courts not at the seat? Is there some sense under German law that there are some remedies that should be available only to courts at the seat? And do German courts make that assessment, asking the question first, are we the seat, and how does that limit our options?
Right. You know, if you look at the provision, it says the courts have to determine whether the application is admissible. So there's also a kind of test where a court could deny entertaining the application. But normally, if you have a witness based in Germany, the German courts would be the logical courts to approach. And if the arbitrator is the gatekeeper, they also know. Parties make an application, say, oh, we want to go to the English courts, we want to go to the German courts, we want to go to some other courts. And then they can determine what's the most convenient forum to entertain the application, to make it useful. Maybe it's different courts, because if you have like evidence based in different countries, you need to apply to different courts because they cannot help you. But that's something, if the arbitrator is the gatekeeper, you also have somebody who can really make all these assessments and who can take a decision. I think that's more effective if you just let the parties run off. And I think that's just another reason, maybe for this kind of policy reason, to allocate that gatekeeper role to the arbitrators.
I'm going to ask our law review colleagues to begin to collect the Q&A cards, but I'm going to ask a further question while they're doing that, which has to do with the German experience under the model law.
Right.
We, of course, have it in California, but very little is known of it still after 15,
Right.
20 years or something. There's a lot of talk about reforming the Federal Arbitration Act in general, or with respect to international disputes and what form that could take. How would you assess the success of the model law in Germany, and how did you get where you are? I mean, were there revisions and
Right.
so on?
But I think when the model law was enacted in 1989, it was quite a bit of a break from the past. So a lot of German law peculiarities were thrown out of the window, and they started, we want to have a fresh start, and they adopted the model law. They made some amendments which are peculiar German, and they might be put on the spot again when there's law reform, because some of them might not have turned out to be such a good idea. But in general, the idea was to also market Germany as a venue for arbitration. And said it's much easier if you can tell people we are model law jurisdiction. So if you know the model law, you know German arbitration law. Make the kind of stumbling blocks to access Germany, because it's normally everything is in German. So you have the language issue. And then if you say, well, I have the language issue, a lot of things are just determined by court jurisprudence. So I need to understand all that. But if you say, the Germans said, no, we have to pull that all back. Because a lot of arbitration law was just put up by the courts in Germany under the old law. So we need to put it in writing so that everybody knows it, and then they know what's happening in Germany. And the German courts are pretty strict in sticking to the interpretation of it. So they don't come up with novel ideas and say, okay, we have this provision, but we think it should be totally differently applied than what's said in the books.
We, of course, in our federal system here, have this constant bedevilment of the state versus the federal law, and trying to explain it to our colleagues abroad is not impossible, but pretty close to that. To what extent does arbitration law of the lender get involved in the German scene, if at all? Is there, it used to be, for example, in Switzerland, that a lot depended on the canton and so on and so forth. Is that problem exist in Germany, or is it very federalized and unified?
Oh, it's a kind of uniform law. It's part of the Code of Civil Procedure, and that applies throughout Germany. But of course, we have different courts applying it, and that's maybe the risk, because some courts are more familiar with arbitration issues than others. And normally you find seats of the arbitration in Frankfurt and Düsseldorf and Munich, the big centers, but there are always seats abroad in very far off places. And if there's an issue, then a court will be seized, which maybe has never seen an arbitration application before. And they might get it wrong. And many of the cases that actually go to the courts are quite weird arbitration cases. It's a kind of associations of dog breeders, because they have an arbitration clause, but they're not dealing in their issues with what normally the commercial arbitration people are dealing with. So they are putting up their friend from another dog breeders association as the arbitrator. So then you have the question of, oh, is that person impartial? And then the courts take decisions on it. Of course, these decisions also then filter down to commercial arbitration, and then they sometimes provide for decisions which are not necessarily perfectly aligned what the arbitration community wants the courts to say. But normally, it's then the Supreme Court which fixes things again.
One of the nastiest disputes I ever had involvement in was between a dog breeder and the putative owner of the dog. That went on for years. I had no idea these things could be so. Do we have any questions in written form? Failing that, I would, using my moderator's powers, invite verbal questions, which I would then repeat so that they would be captured appropriately on our live feed back to Washington and other places. Yes, Professor Childress.
In your view, do courts have too many powers and too much oversight when it comes to arbitration, or too little? And in your view, do arbitrators believe they need more powers in order to not have to deal with the courts quite as much?
So do courts have, in your view, too many powers? And do tribunals have enough powers? And is the balance struck correctly between interference and assistance?
Right. Well, I think if you look at the gaps, the three gaps, I think we need courts. And I think that's something that the arbitration community should acknowledge. And we should try to get on good terms with judges. So you need to communicate with them and you need to get them on board. And if judges try to become critical of arbitration, I think that's quite a disastrous situation. In terms of court control, I think the balance is pretty well struck. Because arbitration, to be an acceptable form of dispute resolution, you need to have some checks and balances. And it's basically the courts who can exercise that function. Arbitral institutions try to monitor things. In particular, if you look at challenging of arbitrators, they get involved in the first step before the courts take a second view and a final view on these things. I think that's pretty well in shape. And I think also in terms of court support of arbitration, I think that's also, you got the infrastructure in many jurisdictions, and I think it's critical to have an infrastructure. But I think it's always a question that there can be outliers. There can always be exceptional cases, and they normally make the headlines. And then you say, oh, we need to push back the courts, or arbitrators got it so far, they got it so wrong in the law, we need to fix it somehow because we can't let that stand. And I think that's a constant discussion, and it always evolves about the individual case. But I think in general, I think we are pretty well established if you look at the model law as an example of balancing court control and court support.
Aaron, you have the honor of being the last question.
No one hold up the progress of the symposium, but my question is, you mentioned in Germany the tribunal acts of the gatekeeper for court assistance, not necessarily so in the U.S. In the U.S., you can obtain evidence to assist a foreign tribunal under 28 U.S.C. 1782 if the tribunal hasn't requested it, if the tribunal says it won't use it, even if the tribunal says sometimes we'll take your evidence and destroy it.
Right.
My question is, if an arbitrator for tribunal is presented with evidence obtained this way, that the tribunal didn't ask for, it may not want, what should an arbitrator do with that?
That's a very tricky
The question is, the question is, like all questions from the beginning, a good one. What should the tribunal do with evidence that is acquired because of the system in which it sits without its permission, not illicitly, but just the system allows it, and even though the tribunal may not have wanted it, is now presented with it?
Right. I think if you look at the model law, the tribunal has the power to assess the admissibility of evidence. And I think that would be the legal basis to make a positive or negative decision on whether to admit this kind of evidence that has been obtained without the formal approval of the arbitral tribunal. But I would be, as a party, I would be very hesitant if the tribunal said we don't want it to try to obtain it and put it try to put it on the file, because then the arbitration tribunal has a problem with it. If they say no, later on maybe the arbitration award can be challenged because they did not do it right with the evidence and the right to be heard. So it always depends on what situation you are in. If you are the party who says, well, I really want to frustrate the whole thing, then you probably definitely want to get the evidence and put it somehow in just to create problems. But if you say, well, you couldn't succeed to convince the arbitrator that this is necessary evidence to be obtained, and there are opportunities to obtain it through US courts, I think then you better leave it. If you're the party who tries to prevail in the arbitration and wants to get it enforced.
Well, in the time-honored fashion, I'd like to initiate a thank you for my friend John Schaefer for that clearly presented and thoughtful presentation. And now my colleague Tom Stepanowicz will start our next mini panel with Professor Chris Strahosel.
Well, it's my distinct pleasure to welcome one of my longtime friends and colleagues in this field, Chris Strahosel, to do our next presentation. Chris could speak on a variety of subjects, and this is a new one that I think you'll find quite fascinating. I'm sure we'll all learn a good deal in the next 45 minutes. Chris is the John Rounds Professor of Law. He's also Associate Dean for Research and Faculty Development at the University of Kansas. He is notably one of the associate reporters for the Restatement Third of U.S. Law and International Commercial Arbitration. He's also done a good deal of work, empirical research, in the area of consumer arbitration in the United States. And many of you realize that the U.S. is somewhat special in that we provide for maximal enforceability of arbitration agreements in all kinds of contracts, including consumer and employment contracts. Chris has actually been working as a special advisor to our Consumer Financial Protection Bureau on some of the empirical work they have done. And Chris, I would love to be able to hear about that today, but we're going to talk about something else. Chris's bio is in the materials, and there's a lot more to say about him. His clerkships, his writing. He is one of the most prolific scholars in our field. But without further ado, I'd like to turn to our topic today. By way of background, you probably know that our state of Delaware is unique in its focus on corporate law. It is the bulwark, the bastion of corporate law in the United States. Vast number of corporations are headquartered in Delaware. Delaware has made a specialty of commercial law, and its Chancery Court is known as the forum par excellence for resolution of commercial disputes. Well, a few years ago, in fact, not so long ago at all, someone had a bright idea that Delaware was the ideal place to create a new kind of arbitration forum, a hybrid, if you will, of its Chancery Court and private arbitration. About 2.5 or 3 years ago, right at this very spot, I was sitting with Chief Justice Myron Steele of Delaware, who was touting all of the advantages of a new program in Delaware for arbitration of commercial disputes. The idea was that this kind of arbitration would actually achieve that much desired trifecta of efficiency and economy, confidentiality, and transparency and reliability in the form of a dependable expert decision maker. Now, I have to tell you that upon beginning to dig into this, and in writing up an essay on our symposium, I began to look more and more closely at it and realized that this was a very controversial proposition because it made the entire process extremely confidential, but also dovetailed with that the potential participation of the chancery judges themselves in this private arbitration process. Chris will tell us more about that in his presentation today. I ultimately, by the third draft of my essay on the process, I ended up being very critical of it. And eventually the Third Circuit, not because of what I wrote, but the Third Circuit did overturn the legislation. So Chris is now going to tell us about Delaware's second time around, and what I think is a really fascinating concept, a new kind of hybrid, if you will, that has many different facets that I think are worth looking at. It's quite different from the last go-around, and I think there may have been some benefit in allowing the drafters to go back to the table. Without further ado, I will turn the podium over to our friend Chris Drahosel. Chris?
Thank you, Tom, very much for the nice and very helpful introduction to set the stage for what else I'm going to be talking about. Thanks also to Trey and Jack for their help in organizing and hosting. Thanks very much to the Law Review folks who've done a fabulous job getting us here and getting us ready. And I very much appreciate all the hospitality. And thanks to everyone else who's here. I'm really pleased to have a chance to talk to you all. I am disappointed the dean's not here. She's actually a Jayhawk. She was at Kansas a lot longer than she was here, and I will say last time I was in Pepperdine, I got a little grief for not stopping in and saying hello to her. So, and then she goes away this time when I'm here. So,
Chris, I think she's not been seen since the NCAA tournament.
Well, I will say my favorite dean, judge/dean Taha story is one time I was here during the NCAA tournament, and KU won its first round game. This was the year Missouri was a number 2 seed and was being predicted to make to the Final Four and lost to Norfolk State in the first round. I don't think I've ever seen her happier, because I got to tell her that, and to see her reaction was priceless. So anyway, my greetings to Judge Taha in absentia. So as Tom said, I'm talking about a new Delaware statute. I don't want to say it's a stretch for this symposium. It fits in the symposium, but it kind of goes beyond the symposium too. It's not an international arbitration statute. It's just an arbitration statute. So it applies to international arbitration, but it also applies domestically. And it doesn't just deal with the interaction between courts and arbitrators and arbitration, but it addresses specifically things in the arbitration process itself. So I'm going a little beyond my charge here, but I think it's a really interesting undertaking by Delaware. And I will give credit to whoever put the program together. I don't know if it was Tom or the Law Review. You guys are way more creative in your title, right? Delaware Tries Again is a lot catchier than whatever innovation in arbitration law in the case of Delaware. So I'm already being put to shame here. But I guess I also should probably thank Mark Cantor on OJMID, which was how I first heard of this statute. So Mark in absentia as well. Thanks for the idea. As Tom said, the background here, which he's already given you most of what I was going to say, involves 5 years ago Delaware adopting a different innovative arbitration statute, where, as Tom said, the key feature was Delaware judges could be arbitrators, number one, and number two, the whole process would be then confidential, right? So basically, one characterization would be you're getting a court hearing before a judge, but the public doesn't find out about it, okay? And this was I'm not sure people really noticed it at first. It took a little while before attention started being paid to it, but then eventually people found out it was actually being used through a securities disclosure made by a company in connection with the merger. You found out that there were, in fact, arbitrations going on, and I guess the number I ultimately heard was about 5 or so cases had been filed. So Delaware would actually tell you how many cases had been filed. You just didn't know who they involved or what was going on. And eventually the actual arbitration itself under this system settled and was also announced. The settlement agreement was also filed with the SEC. But the publicity that the process got as a result led to the litigation that Tom referred to, and ultimately the statute being held unconstitutional. And again, I think if you characterize this as essentially a bench trial where the public is precluded as a matter of course from attending, that's basically what the Third Circuit held, made it unconstitutional. Tom and others have written about this. It's mostly useful here for background. I will say my one reaction to this process is, the supporters of the statute basically argue, well, this is just arbitration. Arbitration processes are always confidential, or at least private in the United States, and more on that later. But there's an important difference between this process and sort of usual private commercial arbitration, and that this is very clearly state action, right? This is government judges, Delaware judges. The money goes to the Delaware court system, as opposed to your usual arbitrations proceeding where the courts have held there's no state action involved, so constitutional protections don't apply. This was a case where very clearly constitutional protections did apply. And so arguably the whole analogy that was being drawn with arbitration was kind of a non-starter, as the Third Circuit at least suggested in a footnote. But again, this is just all background, right? So this is sort of take one in Delaware being innovation. And I will say, as opposed to California and Texas and some other states that count innovation as basically adopting a model statute, i.e. the UNCITRAL model law, yeah, I mean, the UNCITRAL model laws may be innovative compared to U.S. arbitration law generally, but that's just like signing on, right? I mean, that's not being particularly creative in their own right. And so even if Delaware is acting unconstitutionally, at least it's being creative and innovative, and so it's interesting to talk about. Okay. So essentially 5 years later now, we have a new Delaware statute. Okay. This was introduced in the Delaware legislature on March 12th and was signed into law on April 2nd. It's called the Delaware Rapid Arbitration Act. Sounds like sort of mass transit to me, but maybe that's just a West Coast perspective on things. But I do have to say, as I was getting ready for this symposium, end of March, and working on the paper, and it had occurred to me, gee, what if Delaware doesn't enact this statute, right? It's an interesting proposal, but it was at that point just a proposal. I mean, I will say, people were saying, oh yeah, it's going to sail through the legislature, of course it's going to get enacted, but I'm much happier standing up here talking to you about a Delaware statute than a failed Delaware innovative bill, regardless of how interesting it is. So it is Delaware law as of April 2nd. And really there's sort of four different pieces of the law, and then one concluding comment I want to talk about. So the initial question is the scope, right? What sorts of contracts does this apply to? And then, as with any arbitration statute, it addresses issues about enforcing the agreement, about the arbitration proceeding itself, and then enforcing awards and challenging awards. Okay? And then end up with just a few comments on really sort of why Delaware, right? So why is it that Delaware is doing all these creative things and no one else is? This is all preliminary, right? This statute's been in force for barely 2 weeks now. The commentaries are essentially blog commentaries that kind of track what the statute says, so there's not a lot of in-depth analysis of this. So I may be wrong about some of my interpretations. You guys may have other ideas or know other things, so I'm more than happy to be corrected or challenged to think about this more. So these are my thoughts about the way the statute works and some issues that it raises. And again, it's not going to be fully comprehensive even as to that. Okay. So first issue is the scope. When does this statute apply? And what the provisions set out are basically 5 prerequisites for the Delaware Rapid Arbitration Act to apply. It only applies if the arbitration agreement is signed by all the parties to the arbitration. Okay, and I'll talk more about that in a second. Second requirement is that at least one of those parties has to either be incorporated or have its principal places of business in Delaware. Okay, so this is not open to anybody. You have to be a Delaware company to be able to, at least as one party, to take advantage of it. It excludes consumers, and I guess I probably should also in my preface this saying, it's probably just as well I'm not talking about the Consumer Financial Protection Bureau study, because I am not a CFPB spokesperson. I talked to them about the study and did some pieces of it, but I guess I should do my usual qualification that I'm not speaking here on behalf of the CFPB or the US government, even though there's really nothing that I think I will say remotely relevant to it. And again, it makes it much easier for me when I'm not talking about consumer arbitration stuff to not have to worry about that. And here again, the statute explicitly excludes consumers, and more on that one as well. And then the last 2 requirements are in a sense the opt-in piece of it. So you have to have Delaware law applicable to the arbitration clause, and you have to specifically reference the Delaware Rapid Arbitration Act. Okay? And so if you don't have that, the statute doesn't apply. Okay? So I already have set up a nice Westlaw search in the material contracts filed with the SEC to try to pick out contracts that actually agree to this. Probably not surprisingly, in the first 2 weeks it's been in force, none have been filed, but it's really, really early. Okay. One other note on this opt-in piece of it. I don't think there's a lot of FAA preemption issues here. There may be some kind of lurking in the background, and that's something I want to think more about. but the fact that you actually expressly contract for this in Delaware state court, both of those factors should probably mean it's okay under the FAA, under FAA preemption. At least that's my initial reaction. But again, if you guys have thoughts on that, or we can talk about that more. Okay, so on the scope issues, 2 further comments. The first is on the signature requirement. Okay, and that's different than the FAA or more state arbitration laws, right? In the United States, anyway, arbitration agreements have to be in writing, but they don't have to be signed. Okay, and this changes that. And the reason given for the drafters for that change, I think, is just to put at rest any fears that people might have that the Delaware Rapid Arbitration Act would start being incorporated into articles of incorporation or corporate bylaws to bind shareholders. And so the explanation for this requirement given in the frequently asked questions drafted in connection with this proposed bill, when it was a proposed bill, was basically to say, no, that's not possible here.
Chris,
Okay.
let me
Yes.
just, something occurred to me. You raised this very fascinating question of federal preemption, and just before you continue on, am I correct that Delaware has a regular, what we'll call a regular arbitration statute as well? I'm assuming it has some variant
It's
of
got
the
a very-
Uniform Arbitration Act.
Not the
correct?
revised uniform, but the
Right, the original
older
UAA.
uniform. Yes.
So there's another body of regular arbitration law. So in essence, what this is kind of an opt-in to a variant, an arbitration variant, as opposed to normal kind of arbitration.
Yes, absolutely.
Okay,
I mean,
all right.
But one question on those, along those lines that I'll come to in just a second is, I think this is really an overlay on the Uniform Arbitration Act rather than a complete alternative to the Uniform Arbitration Act. If not, it's got some problems, but I'll come to that.
Okay, sorry, thanks.
No, that's
Yeah.
a good
I
point.
thought people might wonder about that.
So one other point, the signature requirement, yes, it keeps the Delaware, the DRAA from being incorporated into the corporate bylaws and stuff, but it has other effects, right? There are other contracts that specify, that include arbitration clauses that are formed without having signatures by both sides. Okay, so I mean, this wouldn't be relevant because consumers are excluded anyway, but credit card bill stuffers are sort of one example, right, where people agree to arbitration even though they haven't signed anything, right? Changes after the fact to your credit card agreement. But there are corporate contracts formed in the same way, right? If you have tacit acceptance of a billing order or something. Basically, this means you could not use the DRAA in those proceedings. Okay, how much difference that makes is another question, and that's one of the themes here is sort of how big a deal are these changes, but it at least excludes the possibility of orally assenting to a contract that has an arbitration clause specifying the DRAA. And I guess the other implication is all the third-party non-signatory issues that are commonly litigated in the courts, presumably a non-signatory could never be brought into a DRAA proceeding because by definition, right, you have to have signed it, and all the non-signatory cases involve people who haven't signed the agreement. Then the second scope issue is the exclusion for consumers, okay, and the commentary or the frequently asked questions and the purposes given for the statute make very clear that this exclusion is designed to protect vulnerable parties from being involved in a DRAA arbitration. And so the question then is, well, how does this work? Okay, the statute says consumers as defined under a different provision of Delaware law. So as a good lawyer, law professor, I looked at that different provision of Delaware law, and it defines a consumer as an individual who purchases or leases merchandise primarily for personal, family, or household purposes. And the personal, family, or household purposes is your usual phrase in American law. That sort of signifies consumer things. What caught my attention was the word merchandise, right? Maybe this is someone who teaches the UCC, but I'm like, merchandise sounds kind of like tangible stuff. And maybe this is a lot narrower exclusion than it looks like based on the terms. However, if you then look at, merchandise is also defined in the Delaware statute. Okay, this is one of the things I try to teach my students, right? You actually want to use definitions, make sure that you follow up on any definitions that happen to be there. And this will be another great example when I'm talking about how words can be defined to mean things differently than their common meaning. The word merchandise is defined very broadly as including intangibles, including real estate, including services. So even though, again, looking at the word merchandise, it sounds narrow, it's actually defined much more broadly to basically include almost everything that consumers do. The one exception being insurance contracts are expressly excluded. Okay, so I guess you could include a DRA arbitration clause. A Delaware insurance company could include it in its insurance contract if it wanted to.
What about a construction contract, Chris?
Well, if it's for personal, family, or household, if it's a home, I would assume if it's a home, somebody's home, it would be inappropriate, or it would not be permissible, would be my reaction.
You used the term lease, or did you mean sale as well?
Sorry, purchases or leases.
Purchase or lease. Oh, I'm
is
sorry,
the-
I'm
is
not
the
looking at that.
statutory.
Okay, thanks.
Yeah, we got our little
Okay.
sheet. You got,
Okay.
rather than me standing
Excellent.
like this the whole time,
I'm
or
trying to
standing
read
like
my-
this,
yeah,
I can,
okay.
yeah, I can,
Okay,
we
thanks.
got our little slide down here. So, it's, again, I think it's a broad definition of consumer other than insurance contracts, because those are expressly excluded. Now, you might think, okay, well, for example, the Arbitration Fairness Act that's been pending in Congress for a long time, that is almost certainly not going to be enacted as long as there's a Republican either in the, some Republicans control one house of Congress and now they control both. Yes, it would make pre-dispute arbitration clauses unenforceable in consumer contracts. It also applies to employment contracts, right? I mean, employees and consumers are usually grouped together as quote-unquote vulnerable parties. I think it's kind of striking that there's no exclusion here for employees. Okay, it seems to me, and I don't know if it was intentional or just an oversight, but if you're really trying to protect vulnerable parties and want to carve out consumers, usually you would carve out employees as well, and this statute does not do so. Okay, and in fact, if you look at the Uniform Arbitration Act in Delaware, it explicitly includes employees as it was within its provisions, and the FAA would make those, essentially require that as well. So maybe employment contracts, again, assuming each individual employee signed, right, rather than that it was just in the some documents they got when they first started work, maybe you could see the DRAA in those contracts, which again is inconsistent, it seems to me, with the idea of excluding vulnerable parties, but that's how I read the statute. Okay, so those are the scope comments I have. I'm sure there's other things to say about it. A few comments on this next phase of the statute, or the next topic the statute deals with, which is enforcing the arbitration agreement. Okay, and this goes to my comment previously about it's not completely clear whether this is an overlay on the Uniform Arbitration Act or whether it is completely separate from the Uniform Arbitration Act. But one thing that's missing from the statute is any provision for a stay of court litigation pending arbitration or an action to compel arbitration under a DRAA agreement. Okay. It's just not there. Now that, I think the way to deal with that is to say that basically this statute is an overlay on the Uniform Arbitration Act, and so the provision that I quote on the bottom of the slide is the Uniform Arbitration Act provision authorizing those procedures. But it is a little bit of a, it would be nice, I think, if you want to try to avoid uncertainty about your arbitration statute, to at least address that issue, either by making clear that the UAA applies when this statute doesn't address something, or by having, I mean, this is a pretty fundamental procedure, right? To basically say a court has to stop what it's doing when there's an arbitration clause with this type of provision in it, and it's just not there. By comparison, there are a number of things, and this is consistent with the idea of the statute supplementing the, oops, sorry, fairly short time frame up there. I need to keep moving the slides anyway. There are other provisions dealing with the procedures for enforcing arbitration agreements that really go beyond what, they go beyond or inconsistent with or contradict what other arbitration statutes would provide. So for example, the DRAA expressly authorizes anti-suit injunctions, right? An injunction against litigation being brought elsewhere under the same contract. Certainly the Federal Arbitration Act, courts will issue anti-suit injunctions, but there's no express authority in the FAA for doing so. And the same is true for the Uniform Arbitration Act. So in this way, the statute goes beyond here, the DRAA goes beyond what, it doesn't change what might be there, it's just clearer about what's there. And then conversely, it expressly precludes the use of, or the issuance of an anti-arbitration injunction. And again, this is a type of, this is basically the party who doesn't want to arbitrate would go to court and say, issue an injunction against this arbitration proceeding. The FAA does not expressly authorize it. Actually, the Uniform Arbitration Act does. Even though the FAA does not expressly authorize it, most courts say you can, and the restatement, international arbitration says that that federal courts can. Here, the DRAA says you can't. Okay. I think that's potentially that's an improvement, although if you think about you're a party who doesn't want to arbitrate, what do you do instead? You just file suit. So I'm not sure, and then you have this whole uncertainty about whether the court actually has the power to stay, which presumably it does, but the statute doesn't say it. So I'm not sure how much of, I mean, I guess this keeps the court from issuing an order, basically finally resolving any upfront issues that it has to resolve before the arbitration proceeding's over. And there's sort of one other provision I'll talk about in just a second, which may make this all not terribly important. But again, this is a definite change from the existing state of the law, let's put it that way. Okay. And then the final thing that I want to talk about as far as enforcing arbitration agreements go is that the DRA expressly says that issues of substantive and procedural arbitrability are issues for the arbitrator to decide. Now, the European ears in the audience and Professor Coe cringe, I am sure, when they hear that, because American courts use arbitrability in a different way than the rest of the world does. Okay? American courts use it. Substantive arbitrability is basically the enforceability and scope of the arbitration agreement. Procedural arbitrability are things like conditions, time limits, and so forth. In the rest of the world, arbitrability really is more, is this claim one that can be arbitrated as a matter of law, which is what the restatement does, which is Professor Coe's one of his sections of primary responsibility in the restatement. But this is language that Delaware courts have used. So I guess I shouldn't be that surprised that that's the language that got adopted into the statute, because Delaware courts have used this have talked about this same distinction.
Chris, do we know what the source of that language is?
No, although again, there's a fairly recent Delaware Supreme Court case that talks about substantive arbitrability issues being for the court and procedural arbitrability issues being for the arbitrator.
I just think it's strange that they use those captions rather than being explicit about what they're the underlying issues.
Which is what the revised Uniform Arbitration Act does.
Yeah.
Is it sets out, rather than just labels, it actually sets out categories.
Right.
And it seems to me that would be a more straightforward way to draft. But again, my sense is they're basically drawing on prior Delaware precedent.
I see.
Okay. And so the prior Delaware law, which is really consistent with federal law, and I think actually the federal law would probably preempt the Delaware law if it weren't, is that substantive arbitrability issues, meaning the enforceability of the arbitration agreement rather than the main contract, and the scope of the arbitration agreement are for the court to decide as a default matter, and procedural arbitrability issues are for the arbitrator. So the bit in the statute about procedural arbitrability issues doesn't change anything, that just codifies the law. Okay? The first part about substantive arbitrability does change the default rule, but my question is, does that really matter all that much, right? Because it is just a default rule under federal law, and if the parties want the arbitrator to decide these issues, they can draft a contract doing so, right? And that's what the Supreme Court held in the Renner Center versus Jackson case, and it's also what every circuit, or virtually every circuit, has held institutional arbitration rules do. The AAA rules essentially have that effect. Now, the restatement disagrees with that, but again, that's a case where we are taking a position contrary to all the authority. The point being, this is something parties could do by contract and frankly do all the time anyway. So this is being touted as a kind of a big deal. Yeah, it changes the default rule, but it's not a huge attraction to this statute because the parties can do it anyway. Okay, so now as far as the arbitration proceeding itself, there are some provisions here that are also sort of noteworthy. This is one of the less noteworthy ones, I think, but it's kind of interesting. Like the Federal Arbitration Act, like the Uniform Arbitration Act, the DRA has a procedure where if the parties can't figure out who the arbitrator is, a court can do it. I think they sort of ratchet the time limits a little shorter to make it more expeditious, so that is a change. In most cases, it's not going to matter because at least if the parties do it right, they will have addressed arbitrator selection anyway, and this provision will be irrelevant. But if the parties don't do it right and you end up under this provision, it's kind of interesting to me that there's sort of three categories of people that a court can appoint, let's put it that way. First is a person named or selected under an agreement, and I have a little bit of a hard time squaring with, this basically kicks in if the agreement doesn't work. So I'm not sure what a category of people named under an agreement really does. Maybe there's a way you can have somebody who would be named under an agreement. Maybe if the agreement sets out qualifications or something, that the court will use those. But that part's just not clear to me what that adds, if anything. The second is an expert in a non-legal discipline that's described in the agreement. So you don't have to have a lawyer as your arbitrator, right? You could have an architect or a business person who knows the industry. Or the court can appoint a Delaware lawyer. Right? So if you want a non-Delaware lawyer as your arbitrator, don't let the court do it for you. Okay, and this is, this is maybe a little more heavy-handed than a lot of. I mean, it wouldn't surprise me if Delaware courts probably would have appointed a Delaware lawyer anyway. It's a little more heavy-handed to actually say that in the statute. I mean, I haven't seen a lot of that elsewhere. Okay, but again, I think in most cases the parties are going to, at least if they're at all sophisticated, going to address this directly. The thing that gets touted most, and really thing for which the act is known, or the way it got its name as the Rapid Arbitration Act, is it sets out fairly strict time limits in the act. So basically, the default rule is 120 days from the time the arbitrator accepts the appointment, or the arbitrator has 120 days from the time he or she accepts the appointment until the award is issued. Okay. Parties can change that. They could specify a different time. That's permitted under the statute. The statute doesn't seem, then the second thing the statute provides is a fixed time of extension, right? So basically you can only get a 60-day extension, right? You can get 2 30 days or 1 60-day, but the total amount of extensions can't exceed 60 days, and from at least the way the statute's written, that can't be changed by the parties in their agreement. So regardless of how long the parties pick in the initial phase, you can only get a 60-day extension, okay? And again, that's something they could probably do in their agreement, except that, right, if the parties agree, they could change any. I mean, if they said no extensions at all, but then they later agreed to an extension, presumably that would be okay because they were changing their agreement, right? They were modifying their contract. It seems to me at least arguable you can't do that under Delaware law. And then the other part, which at least those who are arbitrators in the audience may be interested in, there are serious financial penalties if you fail to comply with these time limits. So if you're 30 days late, you lose a quarter of your fee. If you're 30 to 60 days late, you lose 75% of your fee. And if you're lighter than that, you might as well just go home, right? Because, and I guess one thing that's not on the slide is you actually then have to go tell the Delaware court, right? Like, oh, I'm sorry, I was late with my award. So even if you get no fee, you're probably still better off turning it in than not turning it in. So the idea being, again, this is rapid arbitration, right? We want this to be fast, and we want to make sure the arbitrators don't mess that up. Now, this seems to me something, and I guess I'd be curious, those of you who've been as arbitrators, if you've ever had a contract that had these sorts of provisions in them, because it seems to me you could do this by contract, right? You don't need Delaware statutes to set up that sort of regime. So again, this is another case where, yeah, this is an interesting statutory provision, but the parties could probably change it by contract or could do the same thing by contract. But I'm not sure that anybody does. I certainly haven't seen one, but I'm not an arbitrator.
You know,
Okay.
time limits are more common these days, but normally they're subject to the arbitrator's discretion by specific terms. What's unusual here is to try to limit that in this way. I don't know if any of our experts have seen that. I myself have not.
I mean, I do think that, is it federal, Abe Sofayer has an arbitration group where the arbitration rules, I mean, it's interesting because they actually, I mean, it's all former federal judges, so they use the federal rules of civil procedure as the basis for their arbitration, which is unusual. Not unheard of, but unusual. But there are also strict limits on time, on extensions. That basically, if you want an extension, you have to go beg the administrator to let you have it. And I don't know how strictly they're enforced, but it's the same sort of, and obviously a lot of arbitration institutions have fast track rules or expedited rules. So the idea of speeding up the process isn't unusual, but the way it's implemented here may be a little unusual. And then a final comment on the proceeding itself is confidentiality, right? Because remember, back with the Court of Chancery judges serving as arbitrators, there was a specific provision in the statute that said this is all confidential, okay? This statute doesn't mention confidentiality, and what the drafters say in the frequently asked questions is, well, arbitration is always confidential, so this is going to be confidential. That's a little bit of an overstatement, although in context I think it makes sense, right? I mean, arbitration, most authorities say in the United States, is private, not confidential, right? So the public can't go, right? You can't call up the AAA and ask to see a copy of an award, okay? But if the parties want to talk, they can, right? And there's actually an ethical statement issued by the AAA which basically says that, right? Unless there's a separate confidentiality agreement, anything that's produced in an arbitration, the award, right? Parties can talk about it and release it. So to that extent, saying it's confidential may be an overstatement. Now, there are exceptions. CPR rules, right, Tom's old group, says the parties are also subject to confidentiality. But the AAA rules and the JAMS rules do not. So if you interpret confidentiality here simply as in the same way as the prior statute did, right, that the public can't attend the hearings and nobody will tell you it's going, and the administrator won't tell you where it's going, then this is right. But confidential usually or sometimes is interpreted to mean nobody can talk about it, and that's just wrong. Okay. All right. Few final comments on, and actually I don't want to shortchange this, because in some ways this strikes me, the next couple of things are fairly straightforward, but they strike me as perhaps the most important aspect of the statute. Because a lot of what we've seen so far, the parties could do by contract, right? They can send substantive arbitrability issues to the arbitrator. They can set time limits. They can set penalties that the arbitrators have to pay. Okay. But as far as enforcing or challenging the award goes, there's a couple things that the statute does that parties really can't do by contract, which is consistent with what Jan told us about Germany as well, okay, which is also the U.S. approach. But one thing the statute does is it gives a direct appeal to the Delaware Supreme Court. So you don't have to go to the Court of Chancery and then appeal, you just go straight, and appeal is not the right word, but you challenge the award straight to the Delaware Supreme Court. Now, there is some federal court precedent saying you can waive the right to appeal a district court decision on enforcement of award. So by contract, you could set up kind of a one-tier review, okay? But you can't set that one-tier review to go straight to the Court of Appeals, right? You have to go to the trial court and then waive your right to appeal. Here, you would go straight to the appellate court, okay? And that's not something parties could do by contract. The statute says when you're in the Delaware Supreme Court, you use the FAA grounds for vacating awards. I guess that's got some advantages, right? They're sort of well established. I'm not sure that it's particularly better than the Uniform Arbitration Act grounds, which otherwise would apply. But one thing that strikes me as potentially, I don't say problematic, but at least uncertain about it, is there's at least some question about whether manifest disregard of the law is available. And typically people, particularly commercial entities, don't really like manifest disregard review. So it seems to me this would have been an opportunity if Delaware was really trying to sort of hone in on and narrow down the role of courts to just expressly say manifest disregard of the law review is not available, but didn't do so. So if the U.S. Supreme Court ultimately holds that manifest disregard of the law is available under the FAA, it would also apply here. And then the third thing worth note on the challenge process is the Delaware statute expressly allows you to waive all court review. At least that's how I read it. So you can actually do two different things. You could set up an arbitral appeals panel that made a final review decision with no subsequent court challenge, or you could just have your sort of initial arbitrator decide the case and then have no ability to challenge the award. That's not the case under the FAA. You can't waive the FAA grounds for review. I'm fairly confident the same would be true under the Uniform Arbitration Act. There are some European countries that have the ability to waive review. Interestingly, Switzerland allows you to do it, but only if you're not Swiss. Right? So basically non-Swiss parties can, and the theory is, well, they're going to go back to their home countries, and then you have the Article 5 New York Convention grounds for enforcing or not enforcing awards. And so there is some review, it's just you don't have the Swiss review. That's not the case here, right? Because you have to be a Delaware company in order to use this statute at all. And my reaction is really, if you're a Delaware company, I'm not sure it's such a good thing. Right? Because at least if it's an international arbitration, right? If you want to go enforce the award in Germany, you're going to have to go through the New York Convention process. If the German company wants to come here and you've waived all court review, they get the award, it becomes enforceable, and you have to pay. So there's, at least in international arbitrations, I'm not sure that this is such a big deal, but it's certainly an option that's not otherwise available. Okay. So that's those are my preliminary thoughts on the statute. It's really, I mean, calling it innovation it's different from any other U.S. arbitration law, certainly, and it deserves the title. The final thing I want to talk about in just a couple of minutes, and these are just not well-developed thoughts at all yet, is really why Delaware, right? So now we have two really sort of different attempts by Delaware to types of arbitration laws enacted by Delaware. Okay. I mean, there are things going on elsewhere, right? I mean, there are various states that have enacted the UNCITRAL model law or a specialized international arbitration statute, right? New York courts and I think Florida courts now have specialized international arbitration judges to try to attract proceedings in there. But Delaware's doing some really different stuff, okay? And so the question is, why Delaware? And it seems to me, I mean, I've got a couple quotes that I'll put up here, but there's various possibilities, right? I mean, as Tom said, Delaware is the place to incorporate if you're a Fortune 500 company. And so maybe this type of arbitration proceeding is seen as kind of an adjunct to the sort of incorporation decision and the use of Delaware corporate laws. So you want merger, right? So if you merge your contract with a Delaware company, you can either go to Delaware court or you can do this arbitration proceeding in Delaware, and it's just sort of to make it attractive as an incorporation forum. A second possibility, which this quote I think suggests to me, is maybe it's a broader concern about that. That yeah, Delaware is a good site for incorporation, but if you start looking at applicable law or choice of forum clauses, they're much less likely to use Delaware than would be expected given how many Delaware corporations there are. And so maybe this isn't, as opposed to New York, which does really well. New York, and I think actually Eisenberg and Miller say, New York's won this battle so far as attracting litigation and the use of its law. So maybe rather than just sort of bolstering the incorporation piece of it, maybe what Delaware's doing here is trying to compete better to attract arbitration business rather than the litigation business, but compete in the choice of forum and choice of law realm. And I suppose the third possibility then would be it's really just trying to compete to attract arbitration business like lots of countries and lots of states do. The fact that this statute's limited to Delaware corporations makes that a little less likely, right? There's not going to be a Swiss and a German company coming to Delaware under the Delaware Rapid Arbitration Act because they can't, okay? But then again, there's a lot of Delaware corporations in the United States, and so maybe it's a big enough market that they're willing to limit it to Delaware corporations. So I'm not sure what's going on. The one thing I can say is going on is that this is not about the good, and obviously nothing is the goodness of the Delaware any legislature's heart, okay? But there's basically, there's not a lot, I mean, as you guys know, right, there's not a lot of state legislative history as opposed to Congress, which puts out volumes and volumes of reports and hearings, transcripts. The Delaware report of the report of the Delaware House on this statute was basically 3 sentences, 2 of which are on the slide. So this is the only thing they said in their report on this statute, which basically is, oh, this is a good idea because it'll get our lawyers more work. So clearly that's driving it. I'm just not sure the mechanism by which that incentive gets worked, sort of how it is actually that their real goal here is to get their lawyers more work. So with that,
all right, let's pause right here, and as Jack did in the last hour, let me ask those of you who have written down questions, if you could raise up your cards, and our friend will pick those up. While we're doing that, and in a minute I'll open up the floor to oral questions as well. But before I do that, Chris, let me just raise a general question, a couple of general questions for you. First of all, I think it's very interesting what Delaware has done here. They seem to be saying, we like the idea of trying to create the attractiveness of Delaware as an arbitration forum competing on the international stage, the national and the international stage. And as I was mentioning at the beginning of this segment, originally they were really trying to have the whole trifecta. They were trying to have a uniquely confidential, hermetically sealed arbitration process. That was fast, and also that took advantage of the particular expertise of Delaware Chancery Court judges as arbitrators. You had the whole trifecta. Now you just seem to have, as compared to other arbitration, a fast process. One that is augmented by judicial or procedural rules, court procedural rules, that move everything forward, that expedite the process on the front end and the back, at least potentially, and certainly potentially on the back end. So they seem to be putting their money, their bets, on efficiency and economy. Do you think that will is there anything more?
Well, no, I think that's clearly the main focus of the statute, is on the speed rather than on the other two. I mean, I think my guess is what the drafters would say is that, well, they still have the confidential. It's not more confidential than other arbitration, but neither was the prior process, right? That was not more that was just, it was more confidential than the courts, but it wasn't more confidential than usual arbitration.
Actually, we won't take the time today, but I think you will find that there were aspects of it in terms of the whole process of confirming an award that were rather significant departures from normal procedure. It was truly a hermetically sealed process in some respects. Today, I think you are correct that what we have is just vanilla arbitration in terms of level of confidentiality. And it's really left to the parties' agreement to decide what level of confidentiality you're actually going to experience. Even the general rules do not provide the kind of protection that folks that have trade secrets and intellectual property concerns that they might want to protect. You really need to draft that in. So Delaware hasn't provided us that legislatively. And so it's going to be really interesting to see whether people pick up on this.
Yeah.
Let me ask one more
I will
question.
say,
Yeah,
I will say,
okay.
I mean, you're absolutely right, though. I mean, the difference between this and the prior regime, most fundamentally, is in the prior regime, you had the true experts in Delaware corporate law making the decisions because they were the actual judges who were doing it. And now you can't do that. So yes, you can have expertise, as in people who are Delaware corporate lawyers or other experts in the field, but it's not the same as it was before.
Of course, you can get retired judges, and maybe they'll be fine with that, like many judges. Because you know, the arbitration is now the retirement plan de jure for most American judges. Let me just let's turn to some of our colleagues here. Do we have any? Did you pick up any questions? All right, let's start over here. Maxie, I saw your hand.
Sure. I have a question about the fee limit for arbitrators if they don't comply with the specific time limits in the statute, which I think is very interesting. Actually, my question is twofold. The first is, what is the incentive of an arbitrator to render an award that is 60 days late because his or her fees are reduced to zero? And the second is this a hard rule or are there any exceptions? And the reason I ask this is there might be good reasons and circumstances why the arbitrator is late in rendering the award. It might be that the parties have a certain behavior that he or she is actually not in a position to render the award. So can the court make exceptions to the fee limiting sort of incentive of that?
Okay.
Maxie is asking, is it possible for court-made exceptions to the rather draconian rule relating to the forfeiture of arbitrator fees for a late award?
And the answer is yes. There is a sentence which I did not put on the slide that basically says you can go to the Court of Chancery and it will summarily determine on clear and convincing evidence if there are exceptional circumstances such that the reduction should be modified or eliminated. So, I mean, the sort of preface to your question was once you hit 60 days late, you're not going to get paid, period. Maybe you can get, so to that extent, there's some incentive problems here there's a good incentive to get done early, but if you miss the deadline for some reason, the incentives totally go away. And maybe the court will be willing to take into account things like obstructive behavior by the parties to enable the arbitrator to get paid under those circumstances. Standards, clear and convincing evidence, though. The idea being this is going to be a tough thing to show.
Okay, Bob?
It seems that Delaware missed the boat if it wanted to attract international arbitration. I mean, the impediments of being a Delaware corporation really limits the possibilities that a large amount of international arbitration when it comes to Delaware. Is there any reason why they wouldn't reach out to that rather than just tie it to the Delaware corporation?
The question is it a help or a hindrance that at least one of the parties has to be a Delaware corporation to use this?
I have seen no explanation for that requirement. And it may mean, that suggests to me that of the three possible things that are going on here, it suggests that just sort of flat out trying to attract international arbitration is potentially a relatively small part of it. There certainly were, with the prior statute, the Court of Chancery Judges statute, discussions about how Delaware corporation, a concern that international arbitrations involving Delaware corporations were taking place elsewhere. So I think the focus may be more narrowly on Delaware corporations not resolving their disputes in Delaware than more generally on we want to have international arbitration. We want Delaware to be a center for international arbitration. So on that view, and again, there are a lot of Delaware large corporations. So at least if that's what they're focusing on, they may be happy enough for now with this alternative. I mean, that said, if this turns out to be a roaring success I would see no reason why you wouldn't just amend that out of the statute. And if it turns out lots of companies like it, then why not? But as of now, that's not the case. You're right.
I believe the next hand was George Berman.
Thank you. That was fascinating, Chris. I have a follow-up to Maxi's question, and then just a quick follow-up to that. Trey and I were just sidebarring about something we think we know the answer to. And that would be that there would be no vulnerability to the award that is issued late. You know, we always think about a deterrent to arbitrators is awards that won't get enforced or will get annulled. So we are assuming that if anything, there was a longer deliberative process, not a shorter deliberative process, that there are sanctions, so there's already deterrent. So is there any reason to think that the award is vulnerable? I wouldn't think so.
I mean, the question, go ahead.
Okay.
Sorry, and I need to repeat the question. Sorry,
yeah,
I need to slow down.
Okay, and then the other
Sorry.
thing I want to ask you about is where customs Delaware effects across the board. It would seem that this would be problematic to have Delaware effect if you're going to maintain this, local corporations only, because nobody competes with Delaware. So it seems to me if another state were to adopt this, it might be very tempted not to limit the statute to its own corporations. But if you don't mind, the real question, the only one you need to answer is the following. You said there was little debate, and I was thinking about it must be signed. It doesn't apply to consumers. So there were misgivings about this, some misgivings. We want to protect people from this. So I was kind of interested, what would you have anticipated the debate issues to be? I can think of two of them. One would be the speed factor, and the other one might be, for those of us who are into this, the transfer of substantive arbitrability to the arbitrators. But I wonder if you could say something about what would the debate have been about if there had been a debate.
All right, so I can so three things that George said, even though he said only had to answer one of them. The first was, is there any risk of the award being set aside if the arbitrator's late? I mean, I think, as you know, the usual question there is, have the arbitrators lost their authority when the time limit runs? Typically, courts say no, that they still have the authority. And I would think the fact that there are monetary sanctions would reinforce that, right? It suggests that the sanction here is a fiscal one, not a award one. So I think I agree with that. The second was, I forgot the second one. Oh, right. The second one was, will other states do this? I don't want to, I mean, I'm not an expert in corporate law in Delaware. I think there's maybe I think Delaware is a little less confident in its sort of or sort of controlling role in corporations than it used to be. I think there's concerns about federal law. I'm not sure there's concerns about other states necessarily, although I think like Nevada's actually had a bit of an uptick because of its corporate incorporation statutes. And I think there's sort of international concerns. So I'm not sure that Delaware is not at all worried about that. And in fact, this may be sort of a response to some of these concerns. But it is an interesting question about, well, what if other states now try to compete with something like that? And your suggestion, which I'm now repeating for you since I didn't say this before, is other states might avoid, or given that they have fewer corporations, it might be in other states' interest to just leave out that limitation and adopt the process without the limitation to in-state corporations. And that would make a lot of sense. I mean, absolutely. And then the third question is, what would the debate have looked like? Like, what would the concern here be, or if there were specific concerns about these particular procedures applied to consumer disputes? And again, the limited history doesn't go into that detail. It just says vulnerable parties. I do think the speed was a concern. The shift from courts to arbitrators of substantive arbitrability issues may be a concern. That's certainly something that consumer groups are concerned about under the FAA. Given that it can happen by contract, I mean, it's hard to know how much of an incremental concern that is. The one thing I would add to the list of concerns is discovery. That presumably if you're having a very quick process, the way you speed things up is you have less discovery. So if there were specific concerns, I would think those would be the three. My guess is what really happened and I don't know the Delaware politics, is that it was a lot easier to just get rid of that possible criticism, whatever they might be, to sort of keep that interest group out of the debate by saying we're excluding consumers.
I think that's
without specifics as to what it was.
That makes a lot of sense. I see Jared has his hand up. I know Alan had a comment, but I'm afraid we're going to have to, as a shepherd of time, I've already failed. We do have 5 more minutes.
We have a break. So basically, we're cutting into your break right now.
Okay.
So when Jared and Alan ask questions, blame them. I'm just standing up here.
I was afraid we were going to forfeit our fee if we ran over. So okay, Jared.
I think we've already done that.
Yeah.
So the language regarding the issues of substantive and procedural arbitrability surely come from the first options Housen U.S. Supreme Court case, right? And those are relevant because the FAA vacated grounds are expressly incorporated in here, right? Surely, so what this
sorry.
What this must mean is that they have to, regardless of whether it's a substantive or procedural question of arbitrability, give deference to the arbitrator's decision, because under 5803, the parties have consented basically to submit these questions exclusively to the arbitrator. And then I think the second quick question is regarding the arbitrator who's late, who's more than 60 days late and has no incentive to issue an award. Where does that leave the parties? Isn't that unfortunate because the parties get punished in that process?
Okay, so Jared had 2 questions. One is really how did the procedural and substantive arbitrability issues affect the award? And the statute, it's always described in terms of enforcing the agreement in all the materials related, and that's the place where it is. So I guess one possibility is that perhaps it probably was appreciated, but it may not have fully followed the logic through that if you give arbitrators authority over substantive arbitrability issues up front, you're effectively also subjecting the arbitral determinations on those issues to the usual deferential standards of review, as opposed to the default rule would be the court can decide it up front and the court can review it de novo. Okay, and that's absolutely right, and that's how I would certainly think the act should be applied. It's just not completely clear. Those dots were not connected in anything I have seen written about the statute. So one would hope that that was thought through, but I can't say definitively that it was. And then the second question goes back to the same concern that's been expressed about what happens after 60 days when the arbitrator is not getting any paid anymore. It's the perpetual question about when you sanction things, right? That at some point the sanction can be so severe that all of a sudden there's no incentive left to do anything. And the problem here is, yes, and this was Jared's point, that's going to hurt the parties, right? That all of a sudden the arbitrator's not going to get any money from doing any more work, and the risk is the arbitrator says, I'm not going to do it. Now, there's reputational constraints, right? That the arbitrator is probably going to have a hard time getting reappointed if this person becomes known as the one who basically stopped doing any work once they weren't paid anymore under the Delaware statute, I would think. But yeah, that's I think the idea of the drafters was that's not going to happen because the sanction's so severe. But if the sanction ever gets kicked in, then the incentive goes away. And I think there may be a follow-up question on that.
Wouldn't there be a lawsuit by the parties against the arbitrator?
Well, one thing I did not mention is, so the suggestion is, well, then maybe you have a lawsuit by the parties against the arbitrator on a malpractice kind of theory. One thing I didn't mention is the statute has a very clear arbitral immunity provision, and my guess is, and it just happens to be in this same section of the statute, so my guess is you're exactly right that that's what the people were worried about, is that the arbitrators were worried, well, if this all comes to play, then I might get sued. And I think the arbitral immunity provisions, and unless it's, well, I don't remember what the statute says, I think there's like a willfulness exception. So maybe if you have an arbitrator who just flatly refuses to do any more work when they're not getting paid anymore, that would go outside the scope of arbitral immunity. So in addition to reputation, there may also be a litigation, avoiding litigation incentive to keep doing the work. Good point.
You know, to the best of my knowledge, this is the only state statute that actually attempts to provide an opt-in for narrowed review. As I recall, New Jersey has an opt-in for expanded judicial review of arbitration awards. And of course, there are a number of state courts that have interpreted arbitration statutes to permit expanded or limited judicial review. California, of course, interpreting
and Texas.
and Texas both talk about contracts for expanding judicial review. Chris, a final question. I know
Sorry,
you've written more generally about this whole issue of courts competing with arbitration. You've written about commercial courts in this country, and here we have a hybrid. Does this portend anything for a new wave of judicial experimentation with arbitration? Do you think it's a one-of-a-kind, one-off? Any sense of that?
It's an interesting question. So Tom, oh, you're on the mic, so I don't need to repeat what you said. It's an interesting question, right? Because Delaware is always touted as like the original business court. Although it's not per se a business court in the way some jurisdictions have them, effectively it is. And so it is interesting that the state in the union that's best known for having a high-profile business court is the one that's adopting these sorts of provisions. And again, based on discussions more under the previous statute than under this one, there certainly were concerns about Delaware not having disputes resolved in Delaware or using potentially even Delaware law that prompted enactment of that statute. Whether other jurisdictions will do it, it will be interesting to see, I guess is the best I can say. I guess I'm a little skeptical overall just because parties can accomplish a lot of this by contract. But if you want Delaware, it seems to me if you want your award reviewed by the Delaware Supreme Court, you do this. Otherwise, you can do most of it by contract, is my bottom line as of now. So thank you all very much.
Well, Chris, you provided us with a very delectable dish. Join me in thanking Chris. And now, Catherine, we're going to adjourn to the atrium, and we will reconvene at 11:15. Thanks so much, everyone.